Judgment in the appeal, Lynn Shellfish Ltd and others, and Luce and another.
The Lestrange estate has for many generations owned land adjoining the foreshore on the east side of the Wash on the west coast of Norfolk, and it also holds an exclusive prescriptive right to take cockles and mussels from the foreshore. I'll call that the right. Since 1970, Mr. John Luce has had a tenancy of the right. The Appellants operate fishing boats out of King's Lynn in Norfolk, and in 2007, 13 of their boats fished for cockles in locations which, according to the claim made by the estate and Mr. Luce, the respondents in these proceedings, involve fishing within the area subject to their exclusive fishery, and I shall call that the area. The respondent's claim gives rise to two issues. The first is the location of the western seaward boundary of the area. Is it a fixed boundary or is it a fluctuating boundary? And if fluctuating, is the boundary mean low tide, mean spring low tide, mean neap low tide, or the lowest astronomical tide, the most extreme neap low water, which occurs every 18.6 years? The judge held that it was mean spring low tide, but the Court of Appeal concluded that it was the lowest astronomical tide. The second issue is whether the right extended to sandbanks, which, having been previously separated from the foreshore, became attached to it as a result of the gradual silting up of channels. The respondents contend either that the right applied to the foreshore as it is from time to time, and therefore extended to the sandbanks once they joined the foreshore, or that by the doctrine of accretion, the sandbanks are treated as part of the area once they became attached to the foreshore. The High Court and the Court of Appeal accepted both the respondents' arguments on this issue. Today, the Supreme Court unanimously agrees with the Court of Appeal on the first issue, that the seaward boundary of the area is the lowest astronomical tide mark, but disagrees with the Court of Appeal on the second issue and holds that the area does not extend to previously detached sandbanks when they are attached to the foreshore. There are two important principles which apply to both issues. The first is that, unless it is taken away from them, the public have the right to gather fish and shellfish from the foreshore, and since Magna Carta, it has not been possible for the Crown, the owner of the foreshore, to grant a private fishery which ousts this public right. The second principle is that in order to establish that he has obtained a private fishery by prescription, a person must establish that he has physically enjoyed the fishery as of right for the requisite period. So the extent of the fishery must be determined by the extent of the actual or probable use in the past, and not by inquiring into the mind of the notional grantor. As to the first issue, the Court concludes, 1, that the seaward boundary of the area is a fluctuating boundary, because it is very likely that over the years the public would have gathered shellfish over an area which was defined by the shifting low tide mark, and a fluctuating right would not have detrimentally affected any other interests. And 2, that the most satisfactory low water mark to select is the lowest astronomical tide, as this means that all parts of the foreshore, which are at any time uncovered by the sea, are included in the area. Turning to the second issue, the evidence does not establish that the estate's prescriptive right extends to sandbanks which were not previously joined to the foreshore, as and when they become so attached. In this connection, the fluctuation of the low tide mark boundary is different from the addition of the sandbanks. The fluctuation in the seaward boundary is a gradual process which involves no public rights of any value being lost. By contrast, the attachment of a sandbank to the foreshore will happen at one moment, and if such a sandbank is treated as added to the area, it would mean that the public would have lost the right to take shellfish from such a sandbank. It's unlikely that local fishermen would have accepted the estate asserting an exclusive right to fish over former sandbanks over which the public had the right to fish, simply because they became attached to the foreshore. As to the second point, accretion, The doctrine of accretion is concerned with gradual and imperceptible changes in a boundary, whereas, as already mentioned, a sandbank becomes attached to the foreshore at a single point in time. There is thus no room for the doctrine of accretion in relation to the sandbanks, which became connected to the foreshore in the present case.